Assalamu alaikum and welcome to MLFA's first community webinar and CLE of 2025. This continuing legal education program is approved for 1 hour of credit with the State Bar of Texas for attorneys that are licensed in Texas. We will be emailing details on how to submit the course number, and we'll also be putting the course number in the group chat. I will announce it here just so everyone has it. The course number is 174268696. My name is Aisha Yuki, and I am the Training and Development Manager for MLFA. It is an honor for me to be here today. I will begin by first introducing the organization and then introducing our esteemed panelists. The Muslim Legal Fund of America is a community-centric, grassroots, nonprofit organization fighting for national security reform, upholding and establishing justice in our courtrooms and communities for Muslims in America. MLFA is a nonprofit, full-service defense fund dedicated to defending Muslim civil rights and liberties at the federal level. MLFA is addressing unwarranted action towards Muslims, such as travel restrictions, immigration denials, bank account closures, extra scrutiny of nonprofit work, prisoners denied religious accommodations, unjust prosecutions, and unfair trials, as well as excessive sentences and cruel conditions for Muslim prisoners, informants that are targeting vulnerable youth, and Muslims being intimidated into betraying their faith. MLFA's legal division defends against unjust prosecution, governmental overreach, and systems of oppression through civil, immigration, and criminal litigation, as well as nonprofit legal screenings. All legal services are provided at no cost to our beneficiaries. Welcome again, and for those of you that are just joining, this CLE/community webinar is approved for 1 hour of credit with the Texas State Bar. Next, I would like to start introducing our panelists for today, starting with Sana Salim. Sana joined MLFA in 2023 as the Nonprofit Department Program Manager and Staff Attorney. She was previously a visiting assistant clinical professor with the Indiana University Lilly Family School of Philanthropy. Sana has experience working with Muslim nonprofit organizations, as she was previously a staff attorney with the Muslim Civil Liberties Union, where she advised clients, filed an EEOC charge of discrimination, and pursued post-litigation torts against a federal prison. After passing the Texas bar exam, Sana practiced with Durkin and Graham in the areas of civil litigation and workers' compensation, and Sana is licensed in both Texas and Indiana and practices in the area of nonprofit law. Next, I would like to introduce Huma Khan. Huma is a not-for-profit and family-based immigration attorney and one of the founders of the law office of Tajuddin and Khan, PC, located in the Chicagoland area. She grew up in Columbus, Ohio, and received her undergraduate degree from the Ohio State University, graduating magna cum laude with honors. She went on to attend the Ohio State University Moritz College of Law and received her law degree in 2008. She has lived and worked in the Chicagoland community since 2009, and her goal has always been to be of service to her community. She values helping organizations and individuals navigate the legal issues they face and takes the time to connect to her clients and provide honest and practical legal advice. Next, I would like to introduce Dayala Shamas. Dayala is a senior staff attorney at the Center for Constitutional Rights, where she works on challenging government and law enforcement abuses perpetrated under the guise of national security, both in the United States and abroad. Prior to joining the Center for Constitutional Rights, Dayala was a clinical supervising attorney and lecturer in law at Stanford Law School, and a senior staff attorney supervising the CLEAR project at CUNY School of Law. And finally, I would like to introduce our panelist, fourth panelist, Antonio Glenn. Antonio is an accomplished attorney with a distinguished educational background from the University of Dayton School of Law, where he specialized in business law, graduating in 2008. His legal acumen was further recognized through his admission to the Maryland Bar in 2010, the Texas Bar in 2016, as well as being licensed to practice before the Supreme Court of the United States in 2017 and the United States Tax Court in 2023. Thank you again to all our panelists for joining. And with that introduction, I will be moving into our program. So we would first like to begin with Huma Khan. Huma will be sharing a history of how HR 9495 fits into the LOPE framework. So I'll hand it over to Huma.
All right, good morning, everyone. So I'm just going to jump right in. One of the major distinctions that we want to kind of draw today is the difference between the current system of designation, meaning designating an organization as a terrorist or a terrorist supporting organization, and thereby stripping it of its non-for-profit status, and then versus what's being proposed under HR 9495. So that being said, what I want to do today is actually just provide a historical understanding of the law as it was post 9/11. In particular, I just want to talk about like the legal structure into which a lot of non-for-profits fell and basically never came back out. So hopefully that look back will give us an understanding of what Congress is actually trying to accomplish with this particular bill. So let's dive in. So there are a number of statutes and executive orders which formed the post 9/11 era of designating terrorist organizations and terrorist supporting organizations. And the government basically used the investigatory process behind that designation to shutter certain US-based non-for-profits forever. So these statutes and executive orders are actually, they're still in effect today, but because of certain federal court rulings, they really can't be utilized in the way they were post 9/11, hence us saying, you know, HR 9495. So I'm going to start with IEPA. IEPA is actually a statute that's been in the news lately because that's what Trump's using to do his, you know, Mexico and Canada tariffs. But it's the International Emergency Economic Powers Act. And basically it gives the president sweeping and broad powers to deal with extraordinary threats to the United States. So the statute gives the president the power to regulate and prohibit foreign transactions, transfers between banks, regulate imports and exports, and it actually gives them the power to investigate, block, and seize property that the United States has jurisdiction over because those assets are present in the U.S. So those particular presidential powers that are granted under IEPA are very broad in scope, but they can only, technically speaking, be exercised if the president declares a national emergency. So, and then they're limited further in scope to the subject matter of that declared national emergency. So IEPA is actually a Reagan-era bill that attempted to kind of rein back executive powers, but which Congress felt were unchecked for too long, but it backfired. After 9/11, President Bush, he signed Executive Order 32224, which declared a national emergency under IEPA. And that particular executive order has been renewed every year under every administration ever since. So using that executive order, we've been in a declared state of national emergency with regard to specifically threats from terrorist organizations since September of 2001. And then the powers in IEPA now can be used through that particular executive order. So IEPA together with Executive Order 13224, what it did is it created a specially designated global terrorist list. And it gave the Secretary of Treasury, along with basically through its Office of Foreign Asset Control, which is OFAC, the right to freeze assets of individuals and organizations that were determined to be owned or controlled by or be acting on behalf of these specially designated global terrorists. So basically, the system as it was, and in some degree as it is, basically gave the Treasury Department, in conjunction with the Secretary of State and the Attorney General's office, the power to investigate and designate U.S.-based organizations and individuals as terrorists or terrorist supporting organizations under IEPA and that executive order. So, and then in addition to that, under the Internal Revenue Code, Section 501P, that once an organization is designated under IEPA, it would basically lead to a revocation of that organization's 501c3 status. So that's how things were, and to some degree still are. The Patriot Act, infamous Patriot Act, amended IEPA to allow OFAC basically to go a step further and not only just freeze the assets after an organization is designated, but allowed an organization's assets to be frozen pending an investigation. So even prior to any determination of guilt being made or any designation, an organization would essentially suffer the consequences of that guilt during an investigation. So now the difficulty of having that type of system in place is that it gave non-for-profit organizations that were subject to an investigation almost no ability to appeal or challenge that investigation, either through administrative process, with OFAC directly, or judicial review in the courts. So basically, U.S. non-for-profits at that time found that they could be subject to an investigation without notice, based on classified evidence, which they weren't permitted to see. They couldn't even use their assets to defend themselves because they were preemptively frozen without a warrant. So under that previous post 9/11 system, organizations that were under investigation were basically just stuck between a rock and a hard place. So I think the first thing that's going to come to mind for most attorneys, at least, is, well, isn't that a violation of an organization's due process rights under the Fifth Amendment? So several cases actually at that time did challenge the system based on that principle, but they were unsuccessful. And the Fifth Amendment due process clause, for those of us who are not attorneys, basically is just that no person can be deprived of life, liberty, or property without due process of law. So meaning the right to receive notice of what you're being charged with, the evidence of what you are being charged with, and the right to be heard in court. So some of the big cases, which a lot of us probably remember, Kind Hearts versus Geithner, Global Relief Foundation versus O'Neill, among a handful of others. So the federal district courts who heard the due process cases basically ruled that exigencies of national security and foreign policy considerations overcame any kind of due process arguments that could be made. One of the courts even ruled that OFAC's failure to give a nonprofit foundation any kind of notice or hearing prior to freezing its assets and designating it as a terrorist organization didn't even violate their due process rights, because OFAC's work was serving such an important governmental interest, and that being combating terrorism and stopping the flow of funds to terrorist organizations. So that was the post 9/11 system. No notice, no right to know what evidence is being used against an organization, preemptive seizure and freezing of assets and computers and records, basically without recourse or ability to fight it in any substantive kind of way. So then there was a shift that did occur. Kind Hearts for Charitable Humanitarian Development Incorporated versus Geithner was the case that started kind of to unravel that problematic structure. The federal district court for the Northern District of Ohio actually ruled that the government's freezing and blocking of Kind Hearts assets during the pendency of the investigation was a violation of Kind Hearts' Fourth Amendment rights. So whereas previous cases had all failed, they were utilizing their Fifth Amendment due process defense, and those defenses failed. Kind Hearts' Fourth Amendment claim actually did succeed in 2010. And that Fourth Amendment claim was that the government could not seize or freeze assets without probable cause. So for those non-attorneys present with us today, this means that the court found that the government actually needed probable cause and to obtain a warrant prior to freezing the assets and seizing any records. So if the government now needs to provide the court with probable cause for the issuance of a warrant, right, logically, they would need to provide evidence that could be shared with a judge in order to do so. So it would have to be evidence that was substantial enough to create some type of presumption of probable cause. And this ruling actually put a damper on the government's ability to, what it was doing, unilaterally shut down organizations, without recourse. So we're going to just fast forward a little. In later cases, courts found that in order for them to be able to effectively review a case, they needed to be able to have access to the full administrative record, including any kind of classified documents. So even if that meant that they would have to do so ex parte and in camera, which means that only the judge by themselves is looking at the evidence that's against this organization. So the courts have since also ruled that after such a review of evidence is complete, it actually could lead to the finding that undisclosed classified materials can't be used by an agency when they're making a determination regarding designating an organization as a terrorist or terrorist supporting organization, because just the act of using that evidence and then in turn not disclosing it would give rise to due process violations, but these rulings came after. So basically, to conclude, currently, as things stand, the previous way that things were done was without notice, without having a right to see the evidence against an organization, without any meaningful way to challenge the investigation process or the designation process administratively or in court. That's no longer how the U.S. government can actually use its authority and exercise its authority. So for anyone who's actually interested in a list of statutes and executive orders and cases, I've prepared a PDF which elaborates on those things if you want to go through it and just get yourself like a historical reference point from which to view everything moving forward.
Thank you so much, Hema, for that historical context. I think it's really helpful, and it's a perfect segue into our next section, where we're inviting Sana Salim to explain HR 9495, really to understand why it's concerning and why the lack of due process can lead to subjectivity and abuse of power. So Sana, over to you.
Thank you so much, Aisha, and thanks, Hema, again for that historical context. So what I'm going to be talking about today, like Aisha mentioned, is really just diving deep into the language of HR 9495, comparing it a little bit to the statute that Hema mentioned, which was the Internal Revenue Code Section 501P, which is the current law, and also touching on 6408, which was the predecessor language to 9495. Lots of numbers being thrown at you. So 9495 is called the Stop Terror Financing and Tax Penalties on American Hostages Act, otherwise known as the Nonprofit Killer Bill. It was sponsored by Representative Claudia Tenney out of New York and co-sponsored by 2 Republicans and 2 Democrats in September of 2024. So 6408 was previously passed in the House, and that was back in April of 24, and it died in the Senate. The language here was suspension of tax-exempt status of what we're now calling terrorist supporting organizations, and it was a standalone bill. So basically, that language, 6408 language, became a companion bill to 9495, which talked more about the tax relief for American hostages. So meaning it was tacked on to that bill in the new session of Congress. And that passed, as we all know, in November of 2024. So the language now under 9495 became termination of tax-exempt status of, again, what we're calling the terrorist supporting organizations. And just to set the tone and remind everyone not to panic, yet is that it's still pending in the Senate, meaning it has not yet passed. And I appreciate all of our nonprofit organizations reaching out to me personally, reaching out to MLFA, requesting this type of a presentation, just to kind of dot our I's and cross our T's with how is this going to affect our organization? What can we do going forward? What does this all mean? So that's why we're here today. And that was the motivation for us to put this presentation together, but it has not yet passed. That being said, I'm going to go into the current law, and then we'll get into what HR 9495 says. So current law, like I said, Internal Revenue Code, Section 501P, the suspension, it's called the suspension of tax-exempt status of terrorist organizations. Homa touched on this, but it basically provides for automatic suspension of the tax-exempt status of an organization upon designation or identification by the federal government of the organization as a terrorist organization. So under this system, the designation of the organization, and this is a really big change from the language of 9495, the designation of that organization requires collaboration from at least 4 different government departments. So the State Department, Homeland Security, Treasury Department, and the AG's office all work together to make that determination, versus under HR 9495, it's unilaterally the Treasury Secretary who makes that determination. And I'll get into a little bit more about that in just a minute. So Treasury Secretary is a person who is appointed by the president. And under 501P, the current law doesn't really have any like exclusive decision-making power. Like I said, it's more of a collaborative effort between cross-departmentally under 501P. Now, under this proposed language of 9495, the Treasury Secretary, again, has unilateral decision-making power. And so their first step would be to issue notice to an organization of its intent to designate that organization as a terrorist supporting organization. There are a few rules that they have to follow and notice requirements. So first is that the Treasury Secretary will designate the organization as a terrorist supporting organization. Second, the Treasury Secretary will provide names of other organizations that the C3, the 501c3 organization, has allegedly provided material support to. And then third, the notice has to provide a description of the material support. And it very obviously does not allude to any type of evidence. The language of the bill doesn't require any type of evidence. It's just a description. And from a legal standpoint, those are 2 distinct things. So those are the 3 things that the notice has to include from the Treasury Secretary to the organization. So once the organization has been notified, the organization would have a right to appeal and prove its innocence within 90 days. If that proof is not satisfactory, it would be stripped of its IRS 501c3 tax-exempt status. So this opportunity to cure, as we say, is basically a couple of ways the organization can do it. Number one, it has to determine that it did not, in fact, provide material support or resources to any of those organizations that the Treasury Secretary had listed. Secondly, or alternatively, the organization must try to retrieve any support or resources that they allegedly provided and certify in writing that the organization will not provide any further support or resources. Then the language of the bill gets into rescission of the designation and revocation of that designation. So number one, if it was in fact done erroneously by the Treasury Department, that's one way that that decision can be reversed. But then also there are a couple of procedural processes built in where if the organization actually did not receive proper notice, with those exact requirements that I delineated above, then the designation could also be reversed. So another main point another main difference kind of in remedy under the current 501, the Internal Revenue Code section 501P and 9495 is that under 501P, an organization can seek review in the U.S. Court of Appeals in DC within 30 days. So that's judicial branch. And when they're designated under 9495, they can only appeal under an IRS office called the Independent Office of Appeal. So that's administrative. So that's kind of a key point to note. One thing I did want to talk about was kind of the optics. So the language in 9495 that terminates that tax-exempt status of terrorist supporting organizations is paired with providing tax relief for U.S. citizens and their spouses who are unlawfully or wrongfully detained or held hostage abroad. It basically means that they're trying to add a provision that if there are American citizens abroad, that they don't have to pay back taxes or anything like that if they miss. They're not going to be issued penalties for like missing any of their tax deadlines while they're being held hostage abroad. So it essentially coerced Congress to pass that bill because obviously no one wants to be seen as opposing any kind of tax breaks for U.S. hostages or prisoners abroad. And this very much came out of October 7th and any American Israeli citizens who were held hostage. So I know Diala and Antonio are going to go into much more detail on kind of the chilling effect that this is going to have, the increased scrutiny this is going to have, but kind of from a broad brushstroke, civil rights groups are concerned about this, pro-choice groups are concerned. I mean, it's across the spectrum. Immigration, asylum groups are concerned, environmental groups are concerned. Basically anyone, that's part of an organization that really doesn't align with the president's political ideology. Some of the consequences are financial penalties, public stigma, obviously reputational harm. So they're very real concerns. I think, as I know Diallo will overwhelmingly point out too, that this had a very real, the reason this really even came out was as a result of student encampments and protests back in the spring. I think that's what the impetus was for 6408. But again, the reach and the harm goes far beyond, I think, pro-Palestinian organizations as well. And just some final points to kind of touch on this. It's just there's a problem with subjectivity and abuse of power. Just giving such broad discretion to the Treasury Secretary in particular raises concerns about the potential misuse of the law for political reasons, ideological reasons, significantly lacks due process just by delegating so much discretionary power to the Treasury Department without necessarily having clear guidelines or safeguards in place. And there's too much control in the hands of one government agency without really sufficient checks and balances. So I'm going to stop there. I know there's a lot more to be touched on, and then we'll kind of circle back with some advice and maybe more actionable items that organizations can do going forward.
Awesome. Thanks, Sana, for sharing that. It's super helpful, especially in the current political climate where we're just getting so much news, so many headlines. The media is just covered with all sorts of things that are happening on a day-to-day basis. And I think it is really important for our community to take a step back and really understand what this bill could potentially do. But as you said, I do want to reemphasize that this is, there's still a possibility that it might not pass, right? So there's a lot of preventative work that can be done, and we'll kind of touch upon that towards the end. If anyone has questions that they would like to ask any of our panelists, please make sure you drop that in the chat. So we do have a team going through those questions. So thanks again, Sana. So we'll move next to Antonio. Antonio, if you could please explain kind of how nonprofits or why nonprofits might be hesitant to engage in advocacy work that they may have been engaging in for the past few years, especially on sensitive or controversial issues as have been mentioned. So I'll hand it over to you for that.
Great. Thank you so much, Aisha. So I think one of the things as an attorney working with nonprofits, first and foremost, not understanding the process and what's at stake for the nonprofit. I think Sana talked a little bit about the activism on campus and then being active and definitely seeking to use their civil liberties on campus, where nonprofits who don't have an understanding of the legal compliance standards that they need to adhere to. So first and foremost, it'll just be, getting notated or documented or even mentioned in an article as an organization that has some ties with a terrorist organization. It's almost a stigma that's put onto a nonprofit that they don't really have any recourse to kind of remove from them, either through the legal framework or through public opinion, being able to put out a press release to combat that information or negative stereotype. I think a lot of nonprofits, again, will be hesitant to be more vocal and advocating, especially when it becomes Palestinian or Muslim rights that they're defending and advocating for. In my case research, for the most part, it has been a disproportionate level of scrutiny on nonprofit organizations that are giving or funding money to that area, to Gaza, Palestine, or Muslim organizations. There's been cases, Oxfam, and other cases where you have other humanitarian efforts and nonprofit organizations that are able to give and donate in these conflict zones, I should say, and not have the same kind of repercussions that have been brought against nonprofits who, again, focus on Palestinian or Muslim rights and advocacy. So that's a big impact there. The other thing is not understanding what terrorist supporting is, the definition of it, or material support of a terrorist organization. The rule is knowingly to support these efforts, but sometimes too, you can do it unknowingly. In my research, where even if you're giving indirectly to some causes, and I'll pull up my case information here. Even if you're giving unknowingly to a certain organization, and those funds some way find their way to that terrorist organization as they been deemed, you can be implicated in that as giving material support. So it can be indirect support that's given to that FTO as opposed to direct report. One of the cases, Holder versus Humanitarian Law Project in 2010, where the Supreme Court had ruled, even though the Humanitarian Law Project was trying to give money for peaceful conflict, or to resolve the conflict and stop any terrorist acts, they still were deemed to have violated that. In this situation, they did have to shut down their organization, and the funding went other places, but at the same time it was at a steep price, as the nonprofit had to be dissolved. And so if we know the Holy Land Foundation is a little bit different, but a very extreme case on what with the fear of what the nonprofit doesn't want to encounter, because not only are you having the possibility of losing your nonprofit tax exempt status, that would be mild in the case of Holy Land, where they actually had criminal, prosecution against them in regard to how they were deemed directly supporting terrorism in that situation. And that's something where a nonprofit would be definitely now looking to do that and under greater scrutiny. So I think the first thing for the effect on advocacy is self-censorship, right? The nonprofit would avoid speaking directly about Palestinian rights or Muslim civil rights. We'll start to shut down our First Amendment right, our ability to, critique U.S. foreign policy, which has really prompted this. As mentioned before, the campus activism piece of it, going there to have them protests and fund those, and some of those organizations. Let me pull up here really quick that I had were just the Students for Justice in Palestine being suppressed. University of California, of course, we know the Harvard case study and some of the agreements there with MLFA. But as it looks now, many of the nonprofits now are approaching me as an attorney to figure out what do we need to do, what's our due diligence on how we, combat this, or at least get prepared for this. The other reason nonprofits would, again, step away from the spotlight is you lose donor support, right? Many nonprofits, they're looking for donor support. And if they have tax exempt status, if you lose that, you lose your ability to get any governmental funding, whether it's state or federal. And that could be a big piece of that nonprofit organization's, budget or bottom line and what they're doing for their operations. You have the increased, government scrutiny, and then you also have your donors inquiring on, am I going to be investigated as well? Am I going to be a part of that? Based on my research, most of the efforts to censor a nonprofit haven't gone to the donor level, but under this new administration, that could change. And basically, the Treasury Department, their role would be to peel away the tax-exempt status, but we don't know what they would do to donors who were somehow implicated in giving funds to a FTO or material support to a designated terrorist organization. So some of the things that we'll discuss too, I think I have some more time, is to really increase the legal compliance for the nonprofit organizations to help them combat or prepare for this level of scrutiny. In 2002, the Treasury Department did have an archive report on its response to Arab American and American Muslim communities on guidance on how to give charitably. In the wake of after 2001, you had Muslim organizations who wanted to give charity and didn't want to be deemed on some watch list if they gave to a Muslim organization or nonprofit that was advocating on this behalf. And I think that's something that we'll need to pull out and look at and see what we can do to remedy this if it comes to fruition. Again, as some of the panelists have discussed, the bill has not passed yet, and I think it's I think it's on us to use our advocacy now to really push forward and trying to stop this bill, whether through publicity, whether it's through our efforts to fight this. One thing in my research as well, I found that with Oxfam and some of the other cases that were nonprofits that didn't have an Islamic or Muslim relationship, is that they broadened their scope of what their nonprofit work was to do. So I think for MLFA or other nonprofits, I think collaborating with other organizations that aren't totally Palestinian or Muslim focused gives a good weave and stitch of broadness and strength through collaboration and coalition that would help serve nonprofits moving forward. It'll help advance our cause and story as we use the media and use some of their backbone to some of their organizations' contacts and key pieces to push what we want to get our agenda along with theirs and moving in a more humanitarian effort to get things done, especially when it comes to Muslim or Palestinian things. I think a broader coalition will really help with that. The other organization, Norwegian Refugee Council, also does this as well, where they're in conflict zones, and they've also had cases brought into U.S. Federal court, which they've been able to defend based on their joint advocacy campaigns, even in the war conflict. And I bring up the war conflict because in those situations, they are working with Houthis or Sudan or Yemenis organizations who may be deemed on the terrorist organization list, but because they have a good advocacy group and they're a little more transparent in what their association with them are, they've been able to avoid such censorship and getting shut down by the U.S. government at this point. I think the other things we'll focus on is the engagement in the media and going from there. And then I think the other steps are just a diversified donor base as well, receiving funds from private donors or NGOs who aren't from the same community can broaden us out and help us kind of grow in that area. And again, MLFA does have an audit report for those nonprofits out there who need support and getting their documents reviewed and seen is available, and we can talk about that more offline. So thank you so much.
Thanks so much, Antonio. Really appreciate that insight. So, as he mentioned, whether or not this bill passes, I think in general with what's going on in our national diaspora, I think it's important that we still are proactively kind of making sure how our nonprofits can be empowered. And that's kind of the goal of today's programming and future programs. So next, we would like to invite Diala to share what are some threats that nonprofits do face and how nonprofits can overcome them. So over to you, Diala.
Thank you so much, Aisha and MLFA, for putting together this CLE and webinar. I'm really glad we're having these kinds of conversations, it's a silver lining of HR 9495 having gotten a lot of attention, scared a lot of people, and then not passed, because I do think that these have been important conversations for a very long time. You know, as we said, as we heard post 9/11, charities have come under a lot of scrutiny. So I think in this moment, it's important to kind of really understand what the risks are, but also get like really not cave to the mass panic that I think is intended to be the outcome of these kinds of attacks, whether it's through legislation like HR 9495, but also lots of the public smears and campaigns that we see. Because ultimately, one of the main concerns is that nonprofits end up ceding ground, end up self-censoring, and they end up doing more than what is required by the law. And that is, that is the most resource efficient way for silencing, important advocacy, important humanitarian work. And I think, trying to find ways to be more resilient and understand what real threats are and what are not real threats is a very important part of the work moving forward for people in nonprofit leadership. The previous speakers have covered really well kind of HR 9495 and then the Treasury Department related threats, right? What comes out of the Revenue Code 501p and everything that, you can look to the Treasury Department from to threats that might come from Treasury Department. And Antonio just also mentioned that there are also possible criminal consequences, and that's an important thing to flag. And then the other area that is talked about less, but is still very much there in the sort of threat landscape, is civil lawsuits. And it's another part of this sort of trifecta or this architecture of accusations of support for terrorism and that can impact nonprofits. And I've been focusing a lot on these civil lawsuits. So civil suits, for the non-lawyers listening in, are basically it's not government action. It's when private litigants drag you into the court. And we've been seeing a lot of this. We call this lawfare attacks, lawsuits that are brought to silence, to bankrupt, to deviate your resources away from the work that you're doing, oftentimes by actors who are intending to do, exactly those things. So in the context of the Palestine movement, more broadly, we have a long history of lawsuits accusing nonprofits of so-called material support to terrorism. These are brought under a statute called the Justice Against Sponsors of Terrorism Act, JASTA, as well as the Anti-Terrorism Act, ATA. And the problem with these is that anybody with resources can bring them, even if they're meritless. And we had been paying attention to these. Everybody knows, a very large, prominent, important organization within the Muslim and Palestinian community, American Muslims for Palestine, has been subject to a long-standing lawsuit that kind of draws on the HLF, case. So HLF was Holy Land Foundation was brought up earlier that they were criminally prosecuted, they were designated, but they were also civilly sued by dual U.S. Israeli citizens plaintiffs. And then that case has its continuing life against AMP now. But also in 2019, we represented the U.S. Campaign for Palestinian Rights in a lawsuit that was brought against them under those same statute, accusing them of material support to terrorism. The plaintiffs in that case were Israeli U.S. dual nationals, but also the Jewish National Fund, which is has a quasi-state status in Israel, and obviously a very well-resourced litigant. The case was, like the AMP case, in my opinion, completely meritless. It was really an attack on the boycott movement. What they were doing was trying to argue that the Boycott National Committee, which is based in Palestine, is actually a front for Hamas, and by fiscally sponsoring the Boycott National Committee, the U.S. Campaign for Palestinian Rights, which is based in the U.S., was actually providing material support to terrorism. Now, we defended that lawsuit successfully. It was dismissed at the district court level, then they appealed it. And then we won that appeal, and I tried to go to the Supreme Court, and that was the end of the line. So even though it was a meritless case, it was dismissed at every turn. It still took 3 years, and a team of lawyers, we did it pro bono, but you can imagine that if the US CPR had to pay for their attorneys, it would have been a significant expense and cost. So that's actually another important part of the threat landscape as we're advising clients. Of course, we worry about government action, and we increasingly worry about government action, but we also worry about these very well-resourced litigants who have in their line of sight certain organizations, and they signal to us who those organizations are. After October 7th, we have seen a flurry of these lawsuits, and we now represent UNRWA USA, which is the U.S. nonprofit that helps fundraise in the U.S. to support the UN agency's efforts, its relief efforts in Gaza, but for Palestinian refugees across the region too. They were sued by Israeli U.S. dual nationals, victims of October 7th. And that lawsuit is ongoing. We filed a motion to dismiss. There's also been a couple of other lawsuits really trying to expand the scope of material support to terrorism, targeting the student movement. And I think that's what we're really paying attention to as we see in this moment of everything moving at the speed of, I don't know what. They're pushing a theory that material support for terrorism isn't just, resources as traditionally thought about, fiscal sponsorships, money, material that people think about as actually concrete, but also services that could include advocacy and coordinated advocacy. So with these lawsuits, there's a couple of them, one in the Eastern District of Virginia and another one in Florida. And then there's some smear campaigns that all put out this narrative that campus organizing is actually, part of Hamas's propaganda arm. So student organizations, student activists are actually part of this, Hamas's international propaganda arm. And therefore, these student groups and those who support them in the US are liable for material support to terrorism. So it's, again, a bananas, to use non-legal terminology theory. It's meritless, to use more legal terminology. But it doesn't mean that it's not going to, require being defended in courts. They have to have lawyers to go and file motions to dismiss and so on. And the goal and the purpose is to really drain resources. So that's why we pay attention to these lawsuits. So how much time do I have? A couple of minutes. So I'll just skip ahead. I mean, in addition to watching these state cases, these civil cases, we're also worrying about what the Department of Justice will do. And Antonio touched on this, but at the end of the day, whether it's HR 9495, whether it's these, or whether it's these civil cases, what they're trying to do is accuse you of material support to terrorism. And that is a criminal prohibition. And we've seen it be used in the past, particularly against Muslim organizations. Criminal cases that have been brought against the Holy Land Five and many other people who are still serving sentences. And what I'm worrying is that under a Trump DOJ, we'll see the sort of expansion of that. It hasn't yet happened. The Biden administration had designated as especially designated global terrorist under the provisions that we heard about earlier, AIPA, a Palestinian advocacy organization called Samidun had designated them. And so that might be an indicator of a place where we may see, efforts to kind of expand, because what happens is you first designate groups and then, there's 501c3 implications, but there's also possible criminal implications. So that's something we're watching out for. With all of that said, there are still, this is not intended to be a chilling presentation. The reason we're talking about this is actually we're monitoring these developments, and we've been offering Know Your Rights workshops as well as counseling. MLFA and many and other orgs are doing kind of assessments, and the risk profile looks really differently from organization to organization, right? Your risk profile, if you're sending money to Gaza, looks very different from your risk profile if you're organizing on campuses, is very different from if you're a think tank doing policy briefings. And so it's important to kind of understand what that is and make sure that you have the steps that are in place to make sure that you're protected and that you know what to do, that you have a rapid response plan in place. The last thing I will say is, regardless of what legal liability we're talking about, people also need to understand and have internal conversations organizationally about their risk tolerance, because there's also reputational harm, right? These lawsuits and then the online smear campaigns may not go anywhere in the courts, but they may still be damaging to, staff members or board members getting cold feet, that kind of thing that can really affect organizations' ability to function. And so building some resilience by doing education to staff and board members, so that if you are the kinds of organization that are going to be in the line of sight of these, nefarious lawfare kinds of attacks and smear campaigns, they're ready when it happens and you're able to continue to function. And that means lining up attorneys, making sure that you have insurance, insurance coverage that is robust, so that people aren't worried about their own livelihoods and so on. So we can get a little bit more into what people can do, but I'll stop there.
Great. Thank you so much, Diala, for that. At this time, we will transition into our Q&A portion of the event. First of all, thank you to everyone that has been watching virtually. We have a few questions that came in, so I will start with the first one. Of course, we do have several nonprofit organizations that directly work with Palestine and serve in Palestine. So the first question is a two-part question that I'll open up to all our panelists. As organizations that are serving in Palestine, how should we try to protect our staff and donors? And a follow-up to that, is it possible that private actors may bring these civil suits against not just nonprofits, but also donors? So who would like to take that first?
I can take the first half, but I think Diala is perfect for the second half of that question. So there's guidance that both OFAC and the IRS has given as to what policies and organizations should have in place when they are giving grants overseas or providing funds overseas or working with closely with organizations that are in conflict areas. Now, that guidance then just needs to be transformed into a written policy that everybody in the organization is trained on, is aware of, and then you create procedures and bureaucracy within your organization to make sure that you're actually implementing those policies. Some of the suggestions that the IRS and OFAC make are not practical at all to follow, but other suggestions are actually practical. Like, for example, if you as an organization are giving money, are raising money and giving money to individuals or other organizations in Gaza, specifically, what type of structure do you have in place already to ensure that you are doing background checks through OFAC on who you're giving funds to? That do you have a contract in place with the other organizations that you're working with, in which they have reporting requirements that they're meeting in terms of proving to you how those funds are used, having a paper trail in place? So it's really about implementing policy. It's not fun work. It's tedious work. It often feels like it takes away from the mission of what an organization is trying to do, but it is how you protect yourself.
Thank you.
I can briefly cover the, the problem with these civil suits is they could bring them against anybody. But what we've been seeing is really, because these are being brought by a sort of well-oiled machine and sort of a coordinated group of actors, right? They unfortunately are people with increasing amounts of resources and access to power. But, NGO Monitor and a whole slew of sort of Zionist organizations have been putting out reports for years, building the narratives that they're now deploying through these kinds of lawsuits and lawfare attacks. And so they have sued donors already. Westpac Foundation, well, that was a fiscal sponsor actually, but they're named in some of these lawsuits. In terms of individual donors, we haven't seen that. And I think that if you think about what their goals are to actually target institutions because they want to stop the movement. And so it's probably from their perspective more strategic to go after institutions. But one of the ways they might want to go after institutions is scare their donors and do things like try to get aggressive discovery and like names of donors and so on. I think that's more of what I would worry about than like individual donors to an organization getting sued themselves. But to be clear, foundations like UNRWA USA, our client, is a donor to UNRWA. Like they're basically fundraising in the U.S. They have donors to UNRWA USA that then goes to their resources go to UNRWA. So they certainly are trying to go after what they talk about as the money flows, which is a part of the narrative that they're weaving.
Thank you. Thanks so much for that insight. The next question that we have is, can we learn from other communities, for example, our African American communities, and where in their orgs were deemed terrorist organizations and how they overcame these challenges? Who'd like to take that one? All right, Antonio, go ahead.
Okay, yeah. So in my research, I did a little bit digging into comparable nonprofits like Black Lives Matters, which is more recent. And a little bit of the difference in that was that in some of our nonprofits that we're speaking of now, is a major concern of material support for foreign terrorist organizations. Black Lives Matters didn't get so implicated in that because there were no foreign overseas operations going on, right? So that was a huge distinction there. And I think for the most part, what we learn is in those cases, if your sources in advocacy are somewhat focused more locally, nationally, you may not get implicated as much in or caught up, so to speak, in these situations. So in that case, that's in my preliminary review, that's what I've seen thus far in that, and I think that kind of staves off some of this. There's no really counterpart for domestic terrorism support as it is for this FTO and bringing in the material support. I think January 6th was, in my research, was one of the things that came up as a domestic terrorist support situation. And that's why you had some criminal charges in that for that information. But I think a little bit more research on how to do that. I think that's what we're doing now, is trying to find the remedies and pathways through other nonprofit organizations that have encountered this situation, especially for foreign terrorists or donating internationally, I should say, on that part. We that we can continue to move forward in donating overseas and helping our overseas brothers and sisters with funding without these repercussions. Thanks.
Great. Thanks so much, Antonio. And so for our last question, we have covered a broad range of information related to nonprofit organizations. But again, we are really here to empower our community. And we want to make sure that everyone leaves this knowing that they have legal support, and organizations like MLFA and our guests here, we're here for the community. So what can nonprofits do going into Ramadan, going into next year? How can we really empower our community? Over to our panelists.
I will start, and it will be not shocking to anyone what I'm about to say. And
I think Sunny, are you on mute?
No, we're good.
Can you hear me? Okay. Is just to really for organizations to review and strengthen any and all compliance programs. Antonio's touched on it. I think we've all touched on it. Homa, Diala, we've all touched on it. But really, if you're on it, if you're cleaning up house, great, review it. If you haven't done it yet, please do so. And just diving a little bit more specifically, just make sure you're addressing, making sure that you're financially transparent, that your funding sources have been vetted, your partnerships have been vetted, like Homa spoke about with some of the OFAC, looking at the OFAC database, things like that. And then even having maybe a specific policy, like a know your donor type of policy, establish a vetting process for, all donations, all funding sources, conducting regular audits, whether that's, you bring in an independent auditor, internally reviewing, like I said, the policies, procedures you have in place. We recommend maybe every 2 to 3 year cadence for reviewing your policies. One of the things I always tell clients is that it doesn't matter if you have 100 policies or 10 policies. What's important is you're implementing them, your staff, your volunteers, especially also, sometimes they get left out, are being trained on these policies. Do you have like a new board member orientation? Is that clear? Does everyone know where to find a policy when an issue comes up? Is there, if your organization is concerned, especially about 9495, do you have, maybe a crisis management plan or something like that, where you have an attorney in mind to call as soon as something potentially happens? So, I could go on. I don't just want to kind of throw things at you, but I think that's a great place to start, is what you're working with, what you currently have, what works and what doesn't work, and almost, I don't want to say simplify, but what you do have, the policies that you do have, everyone in-house needs to know about them and know how to access them and know how to implement them.
Awesome. Thanks, Sana. Yep, this is a great time for us to really get motivated to kind of dig back into our nonprofits, reach out to resources, reach out to community partners, and get the resources that we need to empower our organizations, and more importantly, the missions that the nonprofits serve. So just as a reminder, thanks again for everyone that joined. For the attorneys that are on this call, there is a 1-hour CLE credit approved by the Texas State Bar. We'll be sending an email with the course credit number. Stay tuned for our Q2 CLE with the next division of Muslim Legal Fund. And so we'll have another CLE in the second quarter, inshallah. So definitely stay tuned to our social medias to make sure you attend that as well. And we'll aim to have more states for CLE credit for Q2. So thank you again to all of our panelists, to our nonprofit division, and to all of our administrative staff that made this event possible. And Assalamu alaikum.